Well, I think we'll begin. So welcome to the first session of Landmark Chamber's Levelling Up and Regeneration Bill webinar, the first of three webinars. We're delighted to see so many of you joining the session today. Three presentations are going to be given, and there'll be a question and answer session at the end. And I hope, and the rest of the panel hope, you'll find the webinar both useful and informative. My name is Matthew Ree, QC, and I'm going to be chairing the session today. I'm joined by my colleagues, Zack Simons, Matthew Fraser, and Charles Bishop. And I'll introduce them formally in a minute. Before I do that, we've got a few housekeeping points that I'd ask you to note. First, your microphones are automatically muted, so you'll not need to adjust your local settings. Second, of course, we welcome questions throughout the session, and they'll be answered at the end. If you submit them, then do so through the Q&A tab, which can be found at the top or the bottom of your screen. And if you'd like to remain anonymous when you're asking that question, then tick the send anonymously box, self-explanatory perhaps. Before submitting it, we'll endeavour, as I say, to answer as many questions as possible at the end of the session. The third thing to note, the webinar is going to be recorded, is indeed being recorded, and you'll receive a link to the presentation and the recording shortly after the event concludes. And lastly, if your connection is lost during the webinar, then rejoin by clicking on the original link again. So without more, I'll introduce the three speakers. Zack Simons, firstly, is Planning Magazine's top-rated junior planning barrister in the country. He works for a range of national house builders and land promoters with a focus on housing, infrastructure, commercial development and compulsory purchase. He also blogs about planning law and policy at planorex.com, and his presentation is going to be dealing with local plans and housing land supply. Matthew Fraser specialises in planning and environmental law. He's advised the Department for Levelling Up on aspects of the bill, and he has particular experience in litigation relating to the NPPF, having acted in cases like Peel Investments North Limited and Monk Hill. And his presentation will be addressing the bill's approach to national development management policies. Charles Bishop joined Landmark in 2021 following completion of his pupillage. His practice is encompassing all areas of planning, environmental and public law. And in addition to inquiry work, Charles is instructed on a number of planning cases in the High Court, including acting as junior counsel in a judicial review of the grant of development consent for the East Anglian offshore wind farms. And he'll be addressing the bill's effects on neighbourhood planning. So those are our three speakers. We'll turn to the first of those. Zack, perhaps Zack will come on the screen and we'll start to deal with housing land supply. Zack, over to you.
Thanks very much, Matthew. Good morning. Good morning, everyone. I hope you're well. Nice to see that so many of you have joined us. Okay. Well, the problem is easy enough to diagnose. Not enough plans are happening. We all know that, don't we? Too few are adopted. Those which are adopted come too slowly. They're weighed down in process, they're weighed down in politics. Getting a plan to examination can cost millions of pounds of public money, and as we all know, it can ultimately lead nowhere. And in the meantime, of course, many ill effects, hundreds of thousands of homes go unbuilt. Promoters of land are forced to resort to speculative planning applications and appeals. Speculative because there is no plan to rely on, which leads to headlines about the evils of unplanned development, which brings about calls to adopt a plan, and then the cycle repeats and repeats. Who loses? Almost everyone, particularly those people in search of new homes. Who wins? Nobody, other than the few of us in the planning profession who make our living from planning appeals, and local politicians who can gain votes from opposing all sorts of new developments. So far, so familiar. But what does the Levelling Up and Regeneration Bill do to break this vicious cycle? And might it actually work? First, local plans. The bill proposes to change the function of a local plan. At the moment, a plan does lots of different things. It sets a spatial strategy to respond to an area's needs. It allocates sites for development in order to meet whatever those needs are. But it also contains generic development management policies, which include lots of different criteria for determining planning applications. And of course, those policies can take up many pages. Matthew Fraser is going to come back to this in more detail, but the idea is that under the Act, under the bill, that last job about DM policies will be nationalised, National Development Management Policies, which Matt's going to go into. But the consequence for local plans is that their role will evolve. It will be pared down. They will have to be consistent with this new National Development Management Policy and not repeat anything which is set out there. Their function then becomes more spatial. It's much more of a map, what goes where. And we have there an echo of the idea in the 2020 planning white paper for considerably streamlined, pared back local plans. One thing we've heard lots and lots about in recent months is design, the government's priority for high quality design. And one of the headline provisions in this bill is the requirement that plans include design codes. And that might sound like a big deal, but at least so far as the legal provisions go, it isn't really, because all it means is that the plan has to include requirements with respect to design, which they all did anyway, and those requirements don't have to relate to all parts of an area or all kinds of different developments, so it's not exactly going to be a difficult bar to reach in practice. There will be a new process for plan consultation and examination, but the detail of all of that's going to be in regulations, and they haven't been made yet, so we don't know what that's going to say. We understand that plans will require at least two rounds of public consultation, just like they do now. A question I'll come back to is how long all of that is likely to take. I'll deal with that in a few minutes. Another topic which is going to be dealt with in future regulations, not in the bill, is planning data. The bill sets up a legal framework for standardized data processing, making data open and available to all on standardized software, which could, of course, be a very important step to bring our planning system kicking and screaming into the late 20th century. But again, details of all of that are TBD, as are its implications for plan making. Transitional provisions, really important topic, but a topic about which we know nothing. There is, of course, a serious risk that existing plan making exercises are going to slow down or stop altogether. The idea is that new generations of plans will come into effect from 2024. And again, I'll come back in a few minutes to the sort of timelines, the likely timelines for new plans being delivered under the new regime. But note one thing, there is proposed a subtle but potentially important change to the soundness requirement, which is at the heart of the examination of local plans submitted to the Secretary of State. Now, the question for the examining inspector is going to be whether or not whether the plans sound, but whether or not it's reasonable to conclude that the plan would be sound. On the face of it, that potentially sets a lower bar for the examination of local plans, but TBD really in practice, whether it makes a blind bit of difference. That's a very, very quick skim through some of the proposals for local plans. And I'll come back, as I say, in a few minutes to what implications, if any, I think that's going to have for the system. Now, in terms of joint plans and joint strategies, we are, as you know, over a decade since the downfall of regional planning and the Localism Act. What replaced regional planning was the legal duty to cooperate on neighbouring authorities. And that duty has been much criticised as both overly onerous on the one hand and completely toothless on the other, and it's certainly managed to lead to the downfall of a number of emerging local plans. So it's no surprise to see the duty repealed, and the bill proposes to do that. But what is to replace the duty to cooperate in plan making? First, the bill sets out the legal apparatus for joint spatial strategies. Outside London or combined authority areas, councils can, and I'm underlining this word, can, set out joint development strategies for matters of strategic importance, which might include, the bill suggests, infrastructure, it might include affordable housing. If they want to make one, an EIP will be required, and after that, if a strategy is adopted, then local plans in these areas have to be in general conformity with these spatial strategies. A good idea. A potentially powerful idea, I think, but and this might be critical, it's an entirely optional idea. No requirement to undertake these strategies, just the ability to do so if authorities want to. And the same goes for joint local plans. The bill sets up legal infrastructure to do that, positive step, but entirely optional as to which authorities, if any, are going to undertake it. So far as policy goes, when we're thinking about replacements for the duty to cooperate, there is, we are told, going to be a test in national policy that new plans would have to align with those of neighbouring authorities. Not a legal test, a policy test. We've got no detail yet on whether it's going to have any teeth or what it's going to say. And if you take all of that together, I think we have a problem, because many of the most difficult and controversial issues that suppress the delivery of things like housing and infrastructure in this country are strategic or regional in nature. As we know, cross-boundary requirements for infrastructure or cross-boundary spatial policy mechanisms like the Green Belt. Looking at those big issues only through the prisms of particular local planning authority boundaries, as we have been for the last sort of 11 or 12 years, at least outside London and combined authorities, it's going to be a struggle to deliver the sort of joined up thinking we need, I think, in order to really press on with things like the delivery of 300,000 new homes a year. Which takes us to the topic of 5-year housing land supply. Not a topic that's dealt with in the bill, but a topic that's dealt with in policy papers surrounding the bill that will be reflected, we're told, in changes to the NPPF. The proposal, through amendments to the NPPF, is to drop the requirement to show a 5-year housing land supply if authorities have adopted a plan in the last 5 years. It's thought of as a deal with local planning authorities. You adopt a plan, you get on and do it, and then we will make it harder for speculative development proposals to come forward outside the plan. That's the idea. And conversely, you'll need stronger reasons to resist development on sites which are allocated in the plan, which is something that Matt will touch on in his talk later on. All of which you might think sounds perfectly sensible, but there's a problem with this logic. And the problem is footnote 7 of the current NPPF, the effect of which is to disapply the operation of the tilted balance in 11D2 of the framework in cases where there's a quote clear reason to refuse under a number of different sorts of policy of environmental constraints. So, for example, the Green Belt, AONB, etc. Under our current system, local planning authorities within those areas are already, in effect, immunised either from the consequences of failing to show a 5-year housing land supply or from the consequences of failing the housing delivery test. There's no real political downside in lots of these authority areas for failing to adopt a plan, because in the end the tilted balance is not activated anyway. And ask yourself, where are these high profile plans failing? Well, in the southeast, you might think of St Albans, you might think of Welland Hatfield, Hertsmere, Basildon, Castle Point, South Bucks, Sevenoaks, Tandridge. Further afield, you might think of York, Manchester and surrounds, Sheffield. What's the thread that links all of these areas? Areas in which new plans are so desperately needed, and in some cases have been desperately needed for decades. We already know what the thread that links them is that these are authorities washed over by the Green Belt. What does this bill or the proposed changes to the framework do to facilitate plan making in these areas, to change this balance, to break the cycle so that it starts to become in the interests of local politicians to get on and adopt a plan? I don't think it does anything. I don't think the proposed changes do anything at all to change the vicious cycle that we see in these areas, which takes me to process, the streamlined procedure. Not yet in the bill, but no doubt something that will be set out in proposed changes to national policy and regulations. The idea is that plan making takes on a more streamlined procedure. Detail again will be in the regs, as I say, but the fundamental suggestion remains that plans be produced end to end from initial submission, well, not submission, from initial publication to adoption at the end of the process within 30 months. That's the idea. Now, is that a realistic expectation of central government? On the one hand, these new pared down local plans will not need to replicate the reams of policy on detailed development management, because that's all, as I've mentioned, it will all be done at the national tier. So that may speed things up, along with new Technology, which I've touched on, but the detail of it was still TBD. And also proposed as a series of gateway checks during the production of plans, which should help, so goes the idea, spot and correct problems at an early stage in the process, all of which you might think gives us a fair chance of getting the thing done 30 months end to end. On the other hand, the original idea for 30 months end to end local plans was set out in the 2020 white paper. And the key point that underpinned that idea, the point that it was predicated on, was that councils would be handed down plan making targets from central government for things like house building, which the plan would then simply have to get on and meet. But that idea is long gone now. And in lots of places, even with a standard method target in place, it can take 30 months just to debate what the relevant housing target for a plan should be, let alone everything else that a plan needs to do. Plus, of course, resourcing implications. We're told by government that there's no quick fix to the issues that have beset so many local planning authorities and the officers who work for them. There's no doubt about it. The system's horrendously short on money. There are proposed changes, proposed increases to planning application fees, but at the moment the system is on its knees. And without sorting out those issues, the rest, you might think, might be a little academic. I mean, in the end, will the bill increase housing supply, which is one of the key things that the government is intending it to do? I think three things would really help: a strategic approach to things like housing infrastructure needs and spatial policies like Greenbelt, a radical resourcing and skills package, and thirdly, plans that are made more regularly. And unfortunately, sorry to end on a downer, Matthew, I don't see how the announcements so far are likely to do any of those things. So that's all I wanted to say for now. I hope that, to discuss it with you in some questions later on at the end of the session. I'm going to pass over the baton now to, I think, Charles, who will be dealing next with the bill's approach to neighbourhood plans.
Well, thank you for that, Zach. Good morning, everyone. It's great to see so many of you here. I'm going to be talking about neighbourhood planning. And really, I think the bill introduced a number of key changes in the area of neighbourhood planning. What I think we see here is, to some extent, an entrenchment of the idea of neighbourhood planning, first introduced through the Localism Act 2011. And that entrenchment is in the process of an extension, but also refinement. So we see that the basic concept of neighbourhood plans remains, but with some modification. There's greater clarity and further specification of what neighbourhood plans mean and what they can do. And we'll see that that may turn out to be quite significant. But then alongside that, we also see a process of extension of neighbourhood planning. So creation of some new tools at the most local scale. So we have what I might call a form of neighbourhood planning light in the form of neighbourhood priorities statements. I'm going to resist the temptation to call these an NPS, because this is not an area that needs more acronyms, and because we already use that terminology in infrastructure to refer to national policy statements. But I suspect that may be a battle that's lost quite quickly. And then we also have the headline grabbing idea of street votes, but as I'll come to later, that remains something perhaps closer to an aspiration than an actual policy at present. And really overarching all of this is a question mark over how much neighbourhood planning will remain relevant in the context of the general new approach to the interaction between the development plan, national policy, and other material considerations, which is going to be covered in more detail by Matt Fraser. So just useful to go through some of the basic points about neighbourhood plans to begin with. As is well known, neighbourhood plan is part of the development plan. They are consulted on, submitted for examination. Examiner must then consider whether the draft neighbourhood development plan meets the specified statutory requirements, and in particular whether it meets the basic conditions. And then the proposal is subject to a referendum. The examiner needs to decide whether it is appropriate for a plan to proceed, having regard to national policy, and a departure from that policy must be explained. the basic conditions also include a requirement that the neighbourhood plan is in general conformity with the strategic policies contained in the development plan for the area. That requirement, as is well known, is extremely has been litigated quite significantly, but the bill is going to change that quite a bit. And the case law establishes that the degree of conformity required is general conformity with strategic policies, and whether or not there is sufficient conformity to satisfy that requirement will be a matter of fact and planning judgment. So there's a new section created, a new subsection, which provides detail on what can be included within a neighbourhood plan. Although, as we'll come to see, this is actually creating a closed list of what can be included in a neighbourhood plan. But there's nothing here that's particularly surprising. It can allocate land for development, can set out other land use or development related policies to achieve objectives that that particular neighbourhood area wishes to establish in the area, as well as detailing design requirements and infrastructure requirements. Now, the bill replaces that requirement that I just mentioned of general conformity with strategic policies and development plan with a requirement that the making of the plan would not have the effect of preventing the development plan from taking place, effect of preventing development that's proposed in the development plan and which would provide housing. And then what we also see is that neighbourhood plans must not result in the development plan proposing less housing provided by means of development taking place in that area than if the neighbourhood development plan were not to be made. So basically what you're seeing is the neighbourhood plan now needs to be contributing towards housing delivery in a much more significant way than it has before. It cannot be used to restrict housing delivery. But all of this also needs to be read subject to a new requirement that the neighbourhood plan is in general conformity with any national development management policies that are relevant to it, and it must not be inconsistent with or in substance repeat any national development management policy. So really what we're seeing again in this area, and as Matt's going to come on to in a lot more detail, is a sense of a hierarchy of the plans. So the national policy is going to trump all, but allocations in the local plan, so far as consistent with the national policy, are going to retain a special status, and the neighbourhood plan can then be used to design policy around that, but subject at all times to the specific requirements on neighbourhood plans and in national policy. And just flagging here, the new requirement is that the neighbourhood development plan must not include anything that is not permitted or required by the various sections of the legislation. So what that means is it's creating a closed list of what neighbourhood plans can actually provide for, in that if it's not permitted already, then that means the neighbourhood plan cannot cover it. So again, it's this process of refining what a neighbourhood plan can really do. And just on that, we see something here, sort of what you might consider to be a mandatory consideration on those making neighbourhood plans, of whether the plan appropriately contributes to the mitigation of an adaptation to climate change. At least that's one way of reading this provision. There might be other ways of reading this provision that I've included on this slide. I suspect this may be an area that leads to rather great deal of litigation, because there's quite a lot of words in this provision that can be played around with. You know, to what extent does the neighbourhood plan contribute to the mitigation of adaptation to climate change? What's appropriate? What standard is applied here? That's not going to be a straightforward question. And also, you see the neighbourhood plans now will need to comply with essentially the new requirements in respect of environmental outcome reports, which will be discussed in a much later session in this webinar series, but that's replacing environmental impact assessment regime. So those are the changes to neighbourhood plans. Then we've got this new idea of the neighbourhood priorities statements, which are essentially a form of neighbourhood planning light. And the big idea behind this is a recognition that the neighbourhood plan process is lengthy, resource and time intensive, and the government has noticed an inequality in where neighbourhood plans exist, and they want to address that. But I think there is a bit of a question mark over whether this is really going to address that imbalance, because the outcome of a neighbourhood priorities statement process is simply a document that must be considered during the preparation of the local plan. Oddly, there doesn't appear to be anywhere in the bill, unless I've missed it, something which says that the neighbourhood priority statement must be taken into account in deciding any application for developments in the area covered by the statement. So I suspect we're likely to see litigation over the extent to which a neighbourhood priority statement is a material consideration. But perhaps that may be left to resolution through the national policy process, which Matt will come on to. But I suspect that could be an area that could be clarified during the bill's passage through Parliament, and I suspect it is important that clarity is provided, because if the outcome of all this is that a neighbourhood priority statement just has to be considered during the local plan process, then really what is the point of it, and why would neighbourhood want to use that rather than the neighbourhood plan process? And is that really going to address the imbalance? Because it will mean that you've got some neighbourhoods where they've got a much stronger protection of their neighbourhood interests, and others where they don't. Just having some technical difficulties. Yeah, okay. So the bill tells us what a neighbourhood priority statement is and what it can do. But as you can see, quite a lot of the detail is going to be left to regulations. But we do get a sense that basically a neighbourhood priority statement can relate to anything in the neighbourhood area. I think this has been drawn quite deliberately widely, but not sure why there hasn't been mirroring essentially of what neighbourhood plans can do, if the idea is to plug that inequality. And then the devil is going to be in the detail of how you actually make a neighbourhood priority statement. What are the requirements in order to establish one? But what we do know is that there will have to be some form of consultation requirement. It seems like a particularly weak consultation requirement when compared to neighbourhood plans. But I think the absence of any particularly strong statutory power to make regulations here, so there's not a power on the Secretary of State to make really detailed regulations. It's a pretty small provision. It means that we're probably not going to see many onerous requirements in order to establish these. Now, turning to the final idea in the bill in relation to neighbourhood planning, and that's really the headline grabbing one of street votes. And I put on this slide what really is the sum total in the bill of what a street vote is. As you can see, it's very short. It's about 7 lines, something like that. And it's all subject to regulations. The reason for this is that this is deliberately a placeholder clause. That's a device used by government when they want to get the bill process going in Parliament. So they've got everything else ready to go. They want to get it into Parliament because it can be a relatively lengthy process, but they haven't yet fully thrashed out what their policy is going to be on certain parts. So what they're going to do later on is likely introduce an amendment to this provision to make it more detailed and flesh it out a bit, or they might introduce more clauses after it. So really what we've got here is a wait and see provision. But you do get a little bit more of a sense of what's anticipated in the explanatory notes. So the basic idea is a vote on what seems to be a specific proposed development by the street community on whether that specific development should be given planning permission. So the idea is, I think, to improve housing density through the idea being well-considered, well-designed and locally supported proposals. But it's a little bit unclear what the incentive behind this for local communities would be, whether they're really realistically going to be doing this. And it seems slightly incongruous with what government has already recognised in relation to how intensive the neighbourhood planning process can be, that neighbourhoods will then instead go through this street vote thing where they're going to come up with their own planning proposals themselves. And I think the idea of this, I believe, originates from the policy exchange report from February of last year, which was at that point targeted at when planning policy was centred around the Planning for the Future white paper. And you can see there that this idea of street votes had a rather different colour. That was about a street vote on something called a street plan, which was a sort of even narrower version of a neighbourhood plan around a single street. And that fit more within the white paper proposals for renewal areas and so on. But the current proposal, it seems to be a street vote on a specific proposal for planning permission. So actually, we've got a bit of a detachment from where these ideas originally came from. But it may be that some of this some of the detail in the policy exchange report is what this new idea is going to be modelled on. So we may, for example, see how the voting arrangements are going to work being carried across. So in the policy exchange idea, the idea was to have a super majority, so you'd have at least 60% of people on the street voting in favour, and then also some other specific requirements for how many individual households that had to be, because obviously, the number of residents is not the same as the number of houses in most streets. So we'll have to wait to see what this really looks like, but that may be where some of it comes from. But it doesn't appear to be the same idea from what policy exchange originally planned. And really, where does this all lead to? Well, I think it was perhaps best encapsulated in this cartoon in the Telegraph newspaper, which hat tip to David Elvin, who shared it on LinkedIn, and I think quite a lot of people found quite amusing. Really, we're not sure where this will lead, but I think the overarching position is that national policy is going to take on a much greater role in the development of neighbourhood plans, and it remains to be seen whether street votes and neighbourhood priority statements really add anything, or whether they may be a bit of a gimmick. So now I'm going to hand over to Matt Fraser.
Good morning, everyone. I absolutely love going last because all the previous speakers say, and as Matt is going to cover in his talk, and then I think, am I? So I'm going to be covering national development management policies. And I thought I'd start just by looking at where we are currently. And a lot of this will be familiar to people, but I think it's useful just to start here. So national planning policy has a status both in plan making and decision taking. And I'll start with plan making. So as we all know, to be found sound as an independent examination, a draft local plan has to be consistent with national policy. That's one of the requirements of soundness. And similarly, neighbourhood plans have to meet certain basic conditions before they can come into force. And one of these is having regard to national policies and advice contained in guidance issued by the Secretary of State. It's appropriate to make the plan. So national policy is something which local plans and neighbourhood plans already need to adhere to, or at least have regard to, in order for them to be adopted at a local or neighbourhood level. Then when we turn to decision taking, we know from the currently worded section 38.6 that wherein making any determination under the Planning Acts regard is to be had to the development plan, the determination shall be made in accordance with the plan unless material considerations indicate otherwise. And we know what the development plan is. So what are material considerations? Well, one of them is the National Planning Policy Framework. As we know from paragraph 2 of the NPPF, the NPPF is a material consideration in planning decisions. And paragraph 6 goes on to say that other statements of government policy may also be material. Written ministerial statements like that one about affordable housing and the threshold that came up in the West Berkshire litigation, and also endorsed recommendations of the National Infrastructure Commission and lots of others as well, planning practice guidance being another. So inconsistency, the position now is that if you have some national policy that is more recent than an adopted development plan and is inconsistent with it, then that national policy can be a basis for concluding under section 38.6 that material considerations do justify a departure from the development plan. And we also know from the framework, para 218, that policies in the framework are material considerations which should be taken into account with dealing with applications. Plans may also need to be revised to reflect policy changes which this framework has made. And then at 219, however, existing policies should not be considered out of date simply because they were adopted or made prior to the publication of this framework. Due weight is given according to the degree of consistency, essentially. So we're all very familiar with this approach. And so time and time again, in the context of both planning applications and appeals, you have debates about the extent to which national policy and local plans are consistent or otherwise, and whether therefore a local plan policy that's been adopted prior to the framework is out of date. And then why does this all matter? Why does it matter if a policy in a local plan is out of date? Well, we all know the answer to that. Framework paragraph 11D. If the most important policies in the development plan for determining an application are out of date, planning permission should be granted unless the application policies in the framework to protect areas or assets of particular importance provide a clear reason for refusing. Alternatively, the so-called tilted balance, any adverse impacts of doing so would significantly demonstrably outweigh the benefits assessed against the framework's policies as a whole. So we know that a policy is out of date if it's deemed to be out of date due to the absence of the 5-year housing land supply. That's the deeming provision in footnote 7 of the framework. Or a policy might be out of date for reasons unrelated to 5-year housing land supply, namely that it's been overtaken by things that have happened since it was adopted, either on the ground or in some change in national policy. So there is the reference to the fact that national policy can be the reason that a local plan policy becomes out of date. We then get this reminder in the framework of paragraph 12 that the presumption in favour of sustainable development does not change the statutory status of the development plan as a starting point for decision making. Where a planning application conflicts with an up-to-date development plan, permission should not usually be granted. And again, that's the framework, just reminding everyone that the section 38.6 that's the statute, that's what the statute says. The development plan has primacy, it's the starting point, albeit it can be outweighed by other material considerations. So what's going to change with the Levelling Up Bill? Well, the first and arguably one of the most discussed parts of the bill to date is the proposal to replace section 38.6 with a new section 38.5a to 5c. And there are two main changes to note here. The first is that the thing which has given the statutory presumption in favour of is not just the development plan, the thing that's produced at a local level, but also any national development management policies. So section 38.5b says that a determination must be made in accordance with the development plan and any national development management policies unless material considerations strongly indicate otherwise. So that's then the other change. And so what you have is an upgrade of development management policies from being what I would refer to as mere material considerations to actually having the same, equal, and actually more than equal status than development plans, because we then see at 5c, if to any extent the development plan conflicts with a national development management policy, the conflict must be resolved in favour of the national development management policy. So just imagine that a local plan is adopted on the 1st of January 2023. If a national development management policy changes on the 2nd of January 2023, then it doesn't matter what the local plan policy says, the national development management policy takes priority. What is a national development management policy? That's explained further in section 38ZA. It's great how the numbering of the sections is getting increasingly complicated. A national development management policy is a policy, however expressed, of the Secretary of State in relation to the development or use of land in England or any part of England, which the Secretary of State by direction designates as a national development management policy. So essentially, the Secretary of State has the discretion to decide by direction, so by essentially issuing a document that has direction at the top of it that says this is a national development management policy, that then has the status accorded to it in the new section 38. The Secretary of State can modify or revoke a direction or a national development management policy. Before doing so, before making or revoking or or modifying, the Secretary of State must ensure that such consultation with and participation by the public or any bodies or persons, if any, as the Secretary of State thinks appropriate, takes place. So it's a consultation duty. Importantly, and I think this is one of the questions that we've already been asked as a panel, is there going to be an independent examination of national development management policies? The answer is not, unless the Secretary of State thinks that should happen. So obviously the Secretary of State can, if it thinks appropriate, decide to comply with the requirement for participation and consultation by holding an independent examination, but they wouldn't need to do so necessarily. They could have consultations on the similar to how they do at the moment with the framework. There's then a duty in section 15 CA 5C of the 2004 Act, or what will be if the bill is brought into, is given royal assent. And that is that in preparing plans like local plans, minerals, the plan making body must have regard to national development management policies. And that's quite a weak duty. And the reason I say that is because there's then a much stronger duty which applies elsewhere in the bill, which makes one think, well, what's the point of having this mere requirement to have regard to national development management policies? And that is this one: the following documents must not be, according to the Act or the bill, must not be inconsistent with or in substance repeat any national development management policies. Because if you simply have to have regard to something, then obviously you can just disagree with it. But if there's an actual rule that says you can't be inconsistent with or in substance repeat any national development management policy, then that is confirming the supremacy of national development management policies over anything in any of the documents that I've listed there, the most obvious being local plans, neighbourhood plans, and so on. I'll set out all the individual statutory provisions just in case someone wants to follow them through, but I'm not going to read them out. So there's then a specific power in relation to joint spatial development strategies, which Zack was talking about earlier on. This is basically a kind of interfering power. The Secretary of State has an ability, if expedient, to do so for the purpose of avoiding consistency with current national policies. The Secretary of State can intervene before the adoption of a joint spatial development strategy and give a direction to the participating authorities saying, please do not, or you must not adopt this document except in a form which includes modifications in such respects as are directed in the direction to remove any inconsistency with national policy. So once the direction is being given, there can be no adoption unless the plan-making body satisfies the Secretary of State that they've made the modifications or the directions being withdrawn. So again, this is a mechanism that can be used by the Secretary of State to enforce the supremacy of national development management policies. Alongside the bill itself, we are told that there will be an overhaul of the framework following a two-stage consultation. The first being, here are some general ideas that we'd like to flesh out, and then secondly, here is an actual draft of the framework that we want to consult on. Firstly, removing the requirement for authorities to maintain a 5-year housing land supply where their local plan has been adopted within the last 5 years, deciding on which policies will be in the suite of national development management policies, which we are told will be derived from the framework policies, insofar as they're intended to guide decision-making. The rest of the framework will then be refocused on setting out the principles to be taken into account in plan making. There's then a general ambition to streamline national policy by making it more accessible and user-friendly. So what are the take-home points for me on all of this? Well, the first thing to note is that I do think this is a pretty huge shake-up of the planning system, certainly the biggest that we've seen in a number of years. It's promoted as creating a genuinely plan-led system. That's what the further information that accompanies the bill sets out, that's what it's doing, a genuinely plan-led system. But I have to say I disagree with that. I think in many ways it's the exact opposite. It signals what I think of as the demise of the plan-led system in many ways, and the supremacy of national policy. It's a huge refocusing of the power of planning policy into central government's hands as opposed to local government, for the reasons that I identified earlier. That you can essentially have a local plan that adopts a particular policy, and then the minute or the day after it's adopted, if national policy changes, then the national policy trumps the local policy. And similarly, local plans are being told you're not allowed to have any of this other stuff to do with development management policies, because that's something that we're going to be dealing with at a national level now. Thank you very much. So that's obviously a major change. A number of other points just to note. I think one of what I've described here as an awkwardness. I think there is and always has been, ever since the framework came about, an awkwardness to how to reconcile the importance that is given in the planning system to the development plan with the importance of the framework. Because the framework is, you know, the statement of national policy. It's very important. It obviously takes up a lot of time debating what these policies mean, but how does that fit with the development plan? Well, we now know, and hopefully it is going to reduce debates on whether plans are out of date due to inconsistency with the framework. Because whereas now, if you have a national policy which renders a local plan policy out of date, the weight to be accorded to that local policy is still a matter for the decision maker. But under the new Section 38, the old local plan policy effectively gets binned because it gets trumped by the national policy. So you actually can't take it into account. It's not just a question of how much weight you give to it, but it actually just gets superseded. So that's a major change. There is, in my view, a clearer division now of labour between what national and local policies are meant to be doing. Local policies are, as Zack said, much more about spatial matters now. They're essentially saying, where do we want our development to go? And all of the development management stuff is now going to be dealt with at a national level. Similarly, it avoids tensions between Section 38.6 and the framework, paragraph 11D, because national policy trumps local policy where there is an inconsistency. And I've asked the question at the end of the tilted balance, is this possibly signalling the end of the tilted balance? Because you don't need to worry anymore about what consequences must arise from a local plan policy being out of date, because if it's out of date, then it gets binned by Section 38.6 because the national policy takes priority. So, interesting question, is there still a space for a tilted balance in the new regime? I do think it is sensible to put all the generic development management policies in one document rather than repeated across local plans. But I do think that a lot of how to apply the inconsistency and repetition tests for what can be in local plans having regard to national policy is going to be down to, well, how are these concepts to be interpreted in practice. And just one other point, which I didn't put on these comments, but it's a bit of a nerdy legal point for anyone out there who's particularly into this sort of thing, is since up until this new bill, the making of national planning policy has always been something which has been derived from a power given to the Secretary of State as a matter of common law. It's not been something that has ever been derived from statute. So I think this is going to be the first time that we have the power to make national planning policy being given a statutory footing. So anyway, bit of a nerdy point for the lawyers out there, but something that some may well be interested in. So that's the end of my talk. And we're now going to have a question and answer session. So I'll get all the other speakers to turn their phones off and hand over to Matt.
Good, thank you very much for that, Matt. It's very interesting talks, as were Charles's and Zack's. There have been a number of questions that have come up. We've got about 10 minutes, a little shy of 10 minutes to answer some of those questions. So we'll do our best to get through a number of them. Zack, can I start with you, please? One question that came up related to the housing delivery test and the role that it's going to play, at least has been indicated in the bill or by way of any policy documents associated with it. Can you help on that?
Well, short answer is I can't really, other than to say that in my survey of the bill and also of the policy papers that surround it, not much has been said about the HDT, the housing delivery test. I think then that we, at least for now, can and probably should assume that this is a bit of policy that's not going to be touched, that it still bites. It seems to have proven, for whatever reason, a less controversial, I don't know whether you would all agree with this or not, less controversial policy mechanism locally than the 5-year housing land supply policy mechanism. It may be, and this is a topic maybe for a whole nother webinar, that's because it's a policy mechanism that very rarely makes much of a difference, but that might just be my own take on things. But anyway, I think for now, I don't think we should assume that the HDT is going anywhere.
And just allied to the issue of the HDT, in terms of HLS, 5HLS, and its role in the examination of any plans, I mean, can you give any indication, again, not very much in the bill, but by way of anything else that's said by the government outside of it, as to its role?
Well, it's in one of the questions that we had was will it still be the case, as it obviously is today, that local plans which are being examined will have on adoption to demonstrate a 5-year housing land supply? And again, the answer is, I think we should assume that's probably right, but we don't know for sure because it'll all be part of this new package that the government will be consulting on in an updated NPPF. But the consequences will be, as what we've touched on, that if you do end up adopting a plan which as at the date of adoption is found sound on the basis that we assume it'll be able to demonstrate a 5-year housing land supply, then you get your, if you like, 5 years grace period. That's the deal that the government's offering local authorities. Get your 5 years grace period, and at the end of that 5-year period, really one of two things can happen. Either you don't adopt a new plan, and in that case your grace period evaporates, and at that stage we'll be in a situation similar to the one that we've got now, where you know that those who would seek to show that there isn't a 5-year supply can come along and have a go at doing it. That's the first option. The other option is that you adopt a new plan as an authority within that 5-year period, and if you adopt a new plan, then the grace period, obviously the clock starts all over again, and you've got another 5 years of immunity, if you like, from speculative challenges.
Yeah, thanks. Just one last brief question, and before we go on to some of the matters that relate to Charles and Matt, and it concerns the number of or a number of the long-standing draft plans that are out there.
Yeah, and
really, what the consequence is going to be when this bill becomes an act, for the purposes of actually speeding on that process. I mean, you said that you had some doubts about that, some pessimism around it. But how long is it going to take to accommodate the various matters that are now identified in the bill?
Such a good question. Okay, so
my question, somebody else's, so I'm not going to.
No, it's a very good question. We don't know. Again, I feel like that's the repeated thing. We don't know how long all of this is going to take. We know that the government's intention, as it set out in one of the policy papers that accompanies the bill, is that these new plan making provisions kick in from plans that are being made in 2024. Well, we'll see. We'll see about that. There are many questions that are given rise to by that 2024 date. One of them is what happens to all the plans that are being made right now and under the current regime, and what happens to them from 2024 onwards, because of course they're going to include things like development management policies. And heavens help us, that those policies may end up being in some way inconsistent with or repetitious of things that end up being in the national policies that we've just heard about that aren't made yet. So we could very easily find ourselves with new plans adopted in late 2023, immediately superseded. So what are going to be the saving provisions for those sorts of plans? We just don't know. There is a real risk, and a couple of our questions have alluded to this risk. There's a real risk that certain local authorities who almost, and not wanting to be cynical about this, some authorities who perhaps are looking for a reason not to press on full steam ahead with plans, might look at this potential for change in the system and think, well, hang on, is it really worth us now expending the time, the resources, the expertise, and the cash on pushing forward a really difficult, controversial plan if we're actually going to have to do pretty much the same thing, all over again in 2 years' time?
Yeah, there we are. That's a consequence of introduction of new legislation that has the sort of seismic effects that Matt Fraser alluded to. Thanks very much for that, Zack. Can I turn, Charles, to you? Just something that was raised by Zack, actually, in terms of the bill becoming an act. Can you help on the amount of time it will take before this bill turns to law?
Well, we know that it's been introduced in Parliament, and we know that the second reading, which is the next stage in the House of Commons, and really where it really gets going, is going to be in about 2 weeks' time. And after that, there can be quite a lengthy process of examination by various MPs. There's something called committee, where a smaller group of MPs will hear lots of evidence from experts in the area, lots of different, we have to remember, we've just been focusing on plans today. There's quite a lot else in this bill, some of which is going to be controversial around environmental assessment, etc. So this could be quite a lengthy process. I would say probably something like a year, perhaps. The question is whether they try to get it completed before the next Queen's speech, which is presumably going to be around May next year. So I think it's probably looking at around about a year, something like that.
Good, thanks. That's helpful. Another question relates to the planning permissions being granted by street vote. And can you help on the potential for challenging those sorts of decisions?
Well, I think it's quite interesting the way that the provision for street votes is phrased in the bill, because it says the vote is on whether or not planning permission should be given, but it's not clear who's actually going to be granting planning permission. Because if it's sort of the street acting as body itself, then I'm not really sure how on earth that could be challenged, because the question is the street a public authority that could be challenged by way of judicial review or something? I mean, I think this is a bit of a wait and see, and I suspect this might be one of the reasons why the mechanism is being delayed in policy development, because if it's a sort of street votes and then the decision is actually taken by the local planning authority, then that puts the local planning authority in quite a difficult position if they think actually that planning permission should never have been granted. So I think there's some really difficult governance issues around this, and I'm not sure what's going to come of it, to be honest.
No, good, thanks. We're running a little short of time, so I'm just going to turn now, thank you for that, Charles, it's very helpful, to Matt. Just some questions that have come up that relate to things that you've talked about. Just in terms of the management policies, I mean, can you give any indication as to whether any suggestion has been made of the role of the National Design Guide in the production of those management policies?
Well, I think it's definitely a strong contender for the sorts of things that are going to be dealt with at a national level. There's obviously, a lot of design considerations are inevitably local, others are national. So I think anything that can be sort of said at a sufficiently generic level, like what is in the National Design Guide, is just going to find itself being shunted into the new National Development Management policies. There'll obviously still be scope for local plans to have local design policies, insofar as they're not inconsistent with or repeat anything in national policy.
Thank you. We may just run a little over the 10:30 limit. I know that Zack has another meeting, so I'm going to make apologies for him if he bows out before we finish the question and answer session. Thank you for your contribution, Zack. Can I just go back to some of the other questions that have been raised, one of which relates to the role now of development management policies, say on a local level. To what extent may they be included within future local plans, despite the national policy position?
Well, I think there's nothing to suggest that there's not still going to be a role for those kinds of local policies. It's just going to need a bit more careful consideration about, and I'm sure the government will also be sensitive to that in how they frame the national development management policies and what they want to be in them, because they're not going to, they plainly can't start dictating things which can only be governed at a local level. So I do think that there still is going to be scope at a local, in the local plans to deal with those sorts of considerations.
I mean, some comments have come through to the effect that, well, what we're going to be left with really is just a series of allocation policies. And you can, of course, incorporate local design policies within those allocation policies. I mean, to what extent do you see that that's going to be really the result of what the Act, or rather the bill becoming an Act, will pursue?
I think that's obviously going to be the primary function of local plans in the new world. That there will nonetheless be some ancillary matters that will still be dealt with by local plans. I mean, for example, if you think about heritage, there are obviously national heritage policies which will apply and will be national development management policies, but then there may well be local heritage considerations that get given policy status, particular assets, non-designated heritage assets and things like that, which aren't being dealt with at a national level, need to be specified. And so there is scope for those sorts of designations as well, in addition to simply allocations for development.
That's really helpful, thank you. Well, those are all the questions that I think we're going to be able to handle in this session. Of course, there are 2 other sessions relating to the bill that will be held in the next few weeks. Can I just thank each of the panelists again, including Zack, and thank you, all of you, for attending. We hope you found it helpful and enjoyable, and we'll hope to see you at the next stage in this presentation framework. Thank you once again for attending.
Thank you.